So I would hope that CLS at Hastings and here, if we were to change our policy to a policy like Hastings, would be willing to abide by it and include all people, even if they disagree with their beliefs or their lifestyle. I will say I don't have nearly the concern that I have on the political spectrum, where I think we have a political system in which the voices of the very wealthy are drowning out the voices of ordinary people, both in terms of who gets elected to office and, more important, in terms of the decisions that are made by legislative bodies while they're in office. I think this is a huge crisis in our democracy that, frankly, the Supreme Court's precedent up to and including the recent Citizens United decision has largely created and has certainly exacerbated. So I see that as a much greater and more deathly problem than the one that you're referring to. I guess I'm just not that worried about CLS's voice or the voice of religious conservatives being drowned out on campus. But I respect Professor Goldberger's view. I know that he is much more concerned about that than I am.
Well, let me just address, there are 2 points there. The first one is what happens if there is no money. The real power in my household, my wife, had some very strong views that eventually she persuaded me on. Why the hell should any student group get money from the university? You know, if you can't survive on your own, take a hike. Okay? As for, you know, and that sense is, sorry, and if your membership isn't willing to ante up enough to keep you afloat, because how much money does it take to run a student group? You may not be able to afford the pizzas. Now, as to the second position, and that the majority agreed with Professor Tokaji, and that is that the likelihood of a takeover of a group, by a hostile takeover of a group, it was so unlikely the court was unwilling to consider that as part of the freedom of association claim. I think that's wacky. University students are capable of hell-raising, and I'm proud of that. Like I said, most of the time. The Saturday night hell-raising I could do without, but the rest of it, and it's not at all difficult for me to believe that one group would say, look, we've got this group of SOBs that are have a position contrary to ours, there's only 15 of them, let's 20 of us go over there and become members and outvote the sons of bitches and get rid of them. And now, you have, I think, all of the justices have adopted in different ways the position that if that happens, that's a constitutional violation. If, to the extent that the university policy did not protect against that, it's just that the majority thought it was so unlikely that they said no harm, no foul, basically. Is that fair?
If I could just add 2 points by way of response, which I think we disagree. One is that I think that student organizations and organizations, partly by virtue of the fact that they receive university funding, make an enormous contribution to our pedagogical purpose. And, you know, I don't want to trivialize the pizza money, right? That brings people in for like this one. And I guess where I think I disagree is, and I'm looking in the front row at a bunch of my friends and former students who are Federalist Society members, and our political views could not be more different, but I've been honored to participate in a bunch of Federalist Society events this year, and I think you guys make a tremendous contribution to public debate on campus, as is CLS, by co-sponsoring this debate. And I just don't think it's plausible that that contribution would be any less if CLS were required not to discriminate against gays and lesbians. So that was my first point. I had a second point, but rather than that, let's just get a few more questions.
Let me make one comment, though, that is non-substantive. I like Professor Tokaji. When I realized that he spread of groups that was sponsoring this event. It really warmed my heart. I don't mean to say fell in the back.
Yeah, Professor Goldberger, you claim that compelled admission of non-believers place a burden on student religious organizations.
Yeah.
I'm somewhat doubtful of that premise. For instance, I happen to be an agnostic, but I occasionally attend my wife's church and some of their functions, and I'm not aware of any way in which the church members are affected by my presence. Are you essentially using non-belief as a proxy for disruption?
No.
And if so,
No.
is that reasonable?
What I'm talking about is whether or not the non-believers should have a vote on the policy of an organization that is formed for purposes of that particular belief. Your presence there, hey, no big deal. If the university says they can't be, anyone can attend, I don't have a problem with that one either, so long as you're on public facilities. But I do have a problem with having you a full voting member.
And I'm glad you asked this question. I mean, I guess I'm just not nearly as worried about the possibility of disruption or takeover as Professor Goldberger. Look, when we did have a non-discrimination policy in effect here at The Ohio State University that applied to all student groups, not just non-religious ones, we didn't have this problem. And look, if it turns out, as the court notes in its opinion, this does turn out to be a big problem at Hastings or other schools that have a similar policy, then the university is always free to revisit its policy and to change it. The university can always change its policy if it wants to.
Well, let me give you an example. Maybe takeover may be a red herring, and disruption may be a red herring. Let's hypothesize a Muslim student group of 14 people, and that group decides to take a position on the Quran as to whether or not the Quran forbids the publication of pictures of Muhammad. And the group splits 7 to 7. Some say no, can't publish them. The other ones say yes, you can publish. Now let's add in the non-believer. And the non-believer said, oh yeah, you should be able to publish. Should that question be decided by the vote of the non-believer? I respectfully say that non-believers got no business participating in the decision.
I hear Professor Tokaji saying that discrimination is based on sexual orientation, and I hear Professor Goldberger saying it's discrimination based on religion. Professor Goldberger, doesn't that really discount the possibility of a gay Christian, a believer who is also homosexual? And doesn't that change the analysis when you're talking about what's discrimination?
Look, I think that the burden of this belief, okay, falls, I don't agree with it, I don't particularly like it, and it falls heavily on gays. It's not, in my view, not in terms of the greater moral world, is not fair to gays. But that's not what this debate is about. The debate is about whether or not people of the same belief should be able to associate with one another, where there's a policy that says that that belief must include non-discrimination. And to say that there may be a gay Christian, as I understand the position of the Christian Legal Society, is if you as a gay person, not you, but anyone as a gay person, say that that same-sex sex is inconsistent with the Bible and I reject it, my view is that person can be a member and on the board of the Christian Legal Society. And I don't think that, the question is, do you reject the interpretation of the Bible of the Christian Legal Society? And I think most Christians do.
So just a factual point here on the case. The University of California Hastings policy prohibited discrimination based on both status and belief. At least this was interpreted by the Supreme Court. And as I understand CLS's position, there, and I think here, they wanted to be able, at least for officers, to discriminate both against gays and lesbians and to discriminate against non-believers. Now, the Supreme Court in its opinion puts these two things together. It doesn't have to disaggregate for its purposes, since the university's policy applied to both status and belief, and since CLS was apparently wanting to discriminate on both bases, right? One could disaggregate those, and one could imagine a policy that would prohibit student groups from discriminating based on status, such as race, sex, sexual orientation, but not from discriminating based on belief, right? And I think that policy would be perfectly constitutional, as I think the policy that was upheld in the CLS case was perfectly constitutional. Reasonable minds, in my view, can disagree on what the better policy is, but to constitutionalize this and to say that the university can't have either policy is, in my opinion, wrong in the absence of evidence that it was intended to discriminate against particular viewpoints, which I don't think was present in the CLS case.
Let me just tweak Professor Tokaji's answer here. The position, as I understand it, of the Christian Legal Society is that it's an exclusion of unrepentant gays. Now, like I said, I became their advisor not because I agreed with that particular viewpoint, religious viewpoint. I don't agree with it, but I don't think that the state has any business meddling. As far as the constitutionality of alternative points, I want everything that comes out from both of our comments is that the court said that the University of Hastings Law School's policy was reasonable. Maybe not Mrs. Stevens and Ginsburg, maybe not the best policy, but it was a policy that it could choose, so that this is not a decision that says, here is the only policy that is constitutional.
So all you repentant gays out there, you're in line. Yeah, Caitlin.
Professor Tokaji, this is in response to your argument that our university's non-discrimination policy is unconstitutional because it favors religious organizations. The university registration guidelines say that social fraternities and sororities, they limit membership based on sex. And I was Greek in undergrad, I know that they limit based on more than even just that. If religion isn't the only type of group that's getting any sort of preferential treatment, and social fraternities and sororities are too, does that change the analysis?
It doesn't, to my mind. And I don't know. I haven't really thought through the fraternities example. Should the university really be in the business of subsidizing sororities and fraternities? That to my mind is a different question. But even if we decide that that's okay, it seems to me it doesn't necessarily mean that our policy of discriminating in favor of religious groups and against non-religious ones by giving religious groups this exemption is okay. And I'm glad you asked this question because it allows me the opportunity to return to something that David said. I supported David's position on the case involving the religious accommodation of prisoners' beliefs. I think he was absolutely right on that case. I don't remember the exact facts. He can fill you all in. But, basically it was a minority religious adherent who wanted his beliefs accommodated when he was in prison. That, to me, is very different from this case for a couple of reasons. One is that prisoners are stuck there. They have no opportunity to exercise their religious beliefs at all unless they receive this accommodation from the government. The second is that the CLS case involves discrimination in the realm of public debate. I agree with Justice Alito's dissent that because this is a limited public forum, the state can't discriminate based on viewpoint. It can't, in other words, tilt the playing field either for religious groups, as our policy does, or against them, as Justice Alito thought Hastings was doing. And if he were right on the facts, then I would agree with his position. But I think in the realm of public debate, we're not talking about accommodation of an individual's religious beliefs in prison. We're talking about tilt